seated, please. So it's my fault we're 4 minutes tardy. I'm used to 9 o'clock, 8:30's fine for schools, but not for courts. We have 3 cases on the docket this morning. First one is 1524 quadruple 07, Mike Morath in his official capacity versus Kingsville ISD et al. Who's present for the appellant?
Beth Clifton for Commissioner.
Ready? And defendant?
Your Honors, David Campbell here for the appellants.
Good to see you again.
School districts. Good to see you, Judge.
Yeah.
And Your Honor, David Thompson representing the lead plaintiff interveners below in the trial court.
Okay, how are y'all splitting time?
Your Honor, I will be taking 7 minutes and speaking first within the employee's time, and then Mr. Campbell will take 13 minutes.
Okay.
And address other issues.
Count on the bailiff to enforce that, and you're splitting your time, I assume?
Yes, I'm reserving 5 minutes for.
Okay, you may proceed.
Good morning, may it please the court. By issuing accountability ratings, the commissioner would be following, not violating, the education code. First, the commissioner's authority to issue ratings is not contingent on some sort of advance notification of what's going to be in the accountability manual. Second, school districts cannot demand that the commissioner set standards so low that they can earn an A no matter how poorly they perform. And third, the STAR test has been determined to be valid and reliable by an independent third party. For those reasons, the court should reverse the temporary injunction, render judgment dismissing the case, and allow the public to finally see how their districts and schools have been performing. I'd like to start with what I'll call the lateness claim, the idea that too much time has passed that we can't have ratings because of when everything happened during the school year. So I want to make clear, first of all, that the commissioner did adopt the accountability manual during the course of this litigation. There was no contention that that was an ultra vires act. They made no attempt to stop him from doing that. So we have the manual, we have the data. And the only question before the court is, can we put those two things together and issue accountability ratings? And their argument to the contrary hinges on this idea that school districts are entitled by statute to some sort of early notice of what's going to be in the manual so that they can tailor their educational offerings to the students and the programs that will sort of maximize their ratings. But that's simply not there. I imagine they will walk you through the oral argument exhibit that they filed, and looking at the first page, the first line, that it says they need to adopt and announce the accountability rules by the start of the school year. There's, just to put it bluntly, that's language that they have made up. That's nowhere in Chapter 39.
But wouldn't that be a good idea?
That would certainly be helpful, and that's actually usually the case because the commissioner holds standards steady for 5 years at a time. They know when the school year starts what they're going to be aiming for. But this year, for reasons we've detailed in our brief, because he was raising standards and they were making statutorily required changes to the STAR test, there was just a delay. So this year was out of the norm. But for the most part, yes, they do have that kind of notice. But I would also say they know from statute that the prime drivers of their ratings are going to be the STAR test, the CCMR rate, and the graduation rate. They know that. There's nothing stopping them from doing the best that they can in those 3 elements in the first place.
I had a question about the Morath versus Lampasas case.
Yes.
So in that case, the court found that you could interpret a legislative directive that doesn't have a time frame to encompass a reasonable time frame. Does that affect things here?
Oh, okay. So those were, I think, yes, I was thinking of the second part. The first part of the decision said, yes, you need to act. There was no deadline, is what it was. And so they interpreted, well, act in a reasonable time, because we were trying to decide there whether or not a school was or a district was actually going to vote on an annexation or detachment petition, and they just never did. And so the assumption was at some point in time you get to say, you've said no, and we can move on. And that's different than what we have here when the commissioner is prepared to issue these things. 3 months late is not that late, honestly. I mean, the question the court essentially asked in the second half of land passes when they were discussing whether or not the ALJ's failure to reach a decision within 180 days stripped him of the authority to do that. The question is, would you prefer a late decision or no decision? And when we look at the statutes here, it's clear that the legislature would prefer late ratings to no ratings, because the ratings are a key part of the accountability system. We need to know how schools are doing if we're going to invest the resources that we need to help them along, if we need to intervene. That requires multiple years of poor ratings in a row. If we just don't have those ratings, the system doesn't make a lot of sense. And so, sorry, I want to go back sort of to that first point of whether or not they're entitled to those early ratings. While it would be helpful, yes, it is not required by statute. Instead, section 39.0541 states that the commissioner may adopt indicators and standards, quote, at any time during a school year, end quote. So he can wait until the end of the school year when they can't make any more changes and adopt his accountability manual and fully comply with chapter 39. And
I know there's some argument between the parties as to what the provision means that, you have to be able to get an A.
yes, yes.
I know that one interpretation of that is it can't be on a curve. But the other interpretation is, what if you adopt the manual late and then under the new guidelines, no one gets an A? Is that a problem under chapter 39?
No, Your Honor, I would say not, because what we're talking about in section 39054B, which is what you're referencing, is the commissioner must use a method that makes it mathematically possible for everyone to get an A. And so the method is whether or not you're using, for example, a curve where we map everyone and then just chop off the bottom part, or whether you're using these cut scores that would enable them to get an A if they perform well enough. And so the plaintiffs are interpreting that to mean you must set standards that make it factually possible for everyone to get an A. So under their theory, for example, just under the way it's currently set up, we always use the prior year's CCMR rate because that information continues to develop over the summer, so we can't include it in the current year. That's just what he does. But under their theory, if there's a school out there that bottomed out on their CCMR rate, got 30%, that's what the commissioner would have to say an A is. Under that theory, if the commissioner knew what the STAR results were before finalizing the accountability manual, then he's got to set it at the very bottom in order for everyone to be able to factually possibly get an A. And so that's not what's required. If we look at the surrounding context, for example, he's supposed to assign A through F, so there are certainly schools and districts that are going to get less than an A, and he is also supposed to modify the standards to close achievement gaps and make sure that Texas becomes a national leader in post-secondary success. He can't do that if he has to wait and set everything at the bottom in order for everyone then to get an A. He needs to be able to push the school districts forward. And so that's just the result of their interpretation is whatever information he has, if he has that information, well, he's got to set it at the bottom of whatever he knows already. And that's not what this statute was required.
So what changed for the 21-22 year? The school districts say, such and such a district went from an A or a B to an F. What made that happen?
For the manual we're talking about?
Right.
Yes. There were two changes. Number one, there were statutorily required changes to the STAR test, not to make it more difficult, but to make it more reflective of what you do in the classroom. So they weren't allowed to use more than 75% multiple choice questions. So that just took a while to work through the system. And then the second change was that it was time to increase standards. The commissioner had held standards steady for 5 years so that, as they put it, schools could compare apples to apples. They could look at what I did this year and what I did the next year, and those would be judged by the same standards, instead of the past where he'd sort of cranked it up a little bit every year, and so you were always sort of trying to play catch up. Held it steady for 5 years, and it was time to raise standards. So you had a change in the STAR test, and you also had time to raise standards. And so that made the accountability manual this year. That's why it was delayed, but that's also why it was different than the prior year's manual.
And can school districts or individual campuses appeal their ratings?
Under section 39.151, yes. It's usually sort of a mathematical, did you do all of the math correctly to perform the ratings? It's not usually a constitutional challenge or anything like that. But there is a process that districts can go through if they think something has been, incorrectly done with their ratings.
Well, that's what, perhaps I shouldn't have done this, but I'm thumbing through the statute yesterday, and it seems to say 151, the commissioner provides a process for schools to challenge academic or financial accountability rating, and if they have an opportunity to do that and don't, they cannot file any other proceeding. That seems to say we can't do what we're doing.
I guess that,
I'm just.
Sure, and it sounds
School district may not challenge an agency decision relating to an academic accountability rating, including decision relating to termination of consecutive school years, unacceptable performance, in another proceeding if the district or school has had an opportunity to challenge the decision under this section. So if they didn't challenge it under 151.
well, they don't have the ratings yet to challenge. And that's, I think, the problem is that assumes
That's
they're
because-
challenging a rating they've
That's
been
because they got
giving.
the trial judge to refuse to release them.
Yes, Your Honor. And so once they
So
are.
that's all you have to do to be able to file in court. You skip the administrative proceeding, just get a friendly judge to enjoin the proceedings, enjoy the issuance of the ratings, and therefore there's nothing to appeal.
I think the commissioner would not advocate for that understanding, yes. But as I understand 39.151, if those ratings are issued and they believe something was wrong with their rating, that is what they would use. But we do think there is a problem with being able to come into court and raise claims. And then, we are a year after these ratings should have come out, and the public still doesn't know. So yes, we do think that these kinds of lawsuits, they need to be looked at very closely. And again, with respect to just bring it back to sort of their lateness claim, the question is, would the legislature prefer no ratings to late ratings? And there's nothing in the statute that says, that ever takes away the commissioner's authority to issue ratings. There's no statute that ever says, if X, Y, and Z happen, you can't issue ratings. Instead, it's understood that ratings are gonna come out.
And are those the only choices here, like in terms of any type of judicial remedy for the late release of the rating? Is it either no consequence at all or barring the issuance of the rating? There's nothing.
I think so, Your Honor, because we are in the ultra vires world, and so now I don't think barring the ratings is an appropriate ultra vires remedy, so I'll get to that. But yeah, because we're dealing with sovereign immunity, the remedy is up to the legislature. So that's why they have to fit within this ultra vires box. And that says, you can order them to comply with the law in the future. So again, if we had that statute that said no ratings if X, Y, and Z happen, then we could, and X, Y, and Z are at issue, that's when the ultra vires case would kick in. But we don't have that statute. We don't have a statute that makes ratings contingent on the timeliness of the accountability manual. So if you are going to issue an ultra vires order, it would be comply with the deadlines in the future. But you couldn't then attach new consequences, which are, and don't issue ratings for last year, to any sort of past failure. You can only say comply with the law in the future, that prospective relief.
What's the remedy for a district if the new manual comes out and under the new manual, new guidelines, every district gets an F?
I think that the legislature would most likely have something to say about that. Honestly, that's probably how it's going to work out. The commissioner testifies before the legislature with great frequency, and if that were the case, then I think they would be calling him in. But the reality is, even by statute, the commissioner works with stakeholders. He talks to the public, he talks to the districts, he does all of these things when coming up with the accountability manual. So it's not as if he's, it's not a black box that he's sitting there and just working in. It is publicly discussed. And there are 1,200 school districts. There's going to be 1,200 opinions as to what that manual should look like. But the legislature has given that authority to the commissioner to decide, here is where we're going to draw the lines. Here is how we're going to measure success. And so he has not, fortunately, set everyone at an F. But I think, because that's what's realistic. We want school districts to succeed, and we want to set reasonable standards that they can meet. But we also, need to push them forward.
Could I ask a question about the STAR test issue?
Yes.
Are there any other cases that address when an entity is independent in a statutory scheme like this?
I haven't, the closest case that I was able to find was the State versus Volkswagen case, 692 Southwest 3rd, 467, because I didn't get that in my brief. That was when, I admit the circumstances were different, but the governor had to appoint a couple extra members to the Supreme Court because due to recusals, they couldn't get a 5-person majority. And so there was an argument that they also had to recuse because they were appointed by the governor in a case that the state was involved in. And so there were due process and ethics concerns, and the court said no. They had no stake in the case. Merely being appointed by the governor did not mean they could not exercise independent judgment. And so that's what we have here. Their main argument against the TTAC, the Texas Technical Advisory Committee, is that it is called by the commissioner and that they are compensated. But anytime you're going to have an independent third party come and look at this test, you're going to need to ask them to do that, and you're going to have to compensate them for their time.
Before your time runs out, let me ask you about 542.
Oh, yes, I definitely wanted to address that.
So school year is September 1 to August 31 or something else?
There's actually no statutory definition as to when it ends. I would have wanted that, but usually they're looking at the end of May, early June, honestly, for the end of the school year.
So the summer is not part of the school year?
I don't think it's usually considered part of the school year.
So doesn't that, if it says, 542 says you're going to give a simple, accessible format report that explains the measures, methods, and procedures that will be applied for that school year. Why does that not have to happen before, that has to happen before May?
Yeah, yes, if I could finish, I know my time has actually
Sure,
expired.
absolutely.
Yes. So this document, this is essentially a handout. It is taking the 300-page accountability manual and putting it into something that is simple and accessible that the districts in subsection B can then give to the public who wants to understand how the accountability system works. We gave them that document in March. That's 27-02-03 of the record. Now they can pick at it, but we're like, it's a 300-page manual we're squashing into a handout. So there's going to be some details that are left out. And if there was any other questions, the commissioner provided a lot of extra information during the school year that we've highlighted in our brief. So unless there are further questions, I will reserve the rest of my
Thank you,
time
Ms.
for rebuttal. Thank you.
Good morning, and may it please the court, my name is David Thompson. I'm representing the appellees, plaintiff interveners below 62 school districts responsible for educating approximately 1.2 million children. I'm going to take a few minutes, and with the court's permission, I'd like to address one issue. Mr. Campbell will take a majority of the appellee's time and address other issues. The one issue I would like to discuss with the court is the commissioner and the Texas Education Agency's conscious and pre-planned decision to disregard statutory constraints on the commissioner's rulemaking authority. Now, at the very outset, we hope it is absolutely agreed that agencies cannot confer on themselves rulemaking authority. Rulemaking authority is given by the legislature. Agencies must exercise that authority within those constraints. I would like to call the court's attention to 3 undisputed facts in the record. Number one, the agency's own witness, the Associate Commissioner for Accountability, testified that there was absolutely no statutory requirement to update the accountability system for the 22-23 school year. That was a discretionary decision that the commissioner simply chose to do. It was not in furtherance of any legislative requirement. That's fact number one. Fact number two.
Wait. So if an agency decides they're not going to do anything, that's a rulemaking procedure?
No, Commissioner, I'm sorry, Your Honor, I will get to the agency's adoption of rules in just a moment, but take that fact. Fact number two, that decision was actually a departure from 40 years of history in Texas. Every time we've implemented a new test in Texas, and make no mistake, the STAR is the same name, but it is a new test. And I believe even the commissioner has spoken publicly to that. Without exception, in Texas history, when we implement a new test, we implement it in 1 year, And then the next year, once you actually know how the test is operating, you make the adjustments to the accountability system. The 22-23 year is the only time in history that the agency attempted to implement a new test and simultaneously change the accountability system without knowing how the test was going to operate. And frankly, we believe that decision probably contributed to the agency missing virtually all of the statutory deadlines. And then the third thing I would like to call the court's attention to.
So where does that rule come from?
Here are the rules. If you look at 39054, we'll start there. 39054A is actually the statute that says the commissioner will adopt rules for A through F grades. But, Your Honor, look at the first 6 words. Except as provided in subsection A4, the commissioner shall adopt rules. So A4 is actually a limitation on rulemaking authority. What does A4 say? A4 talks about circumstances that are beyond the control of districts and campuses.
I'm sorry, say that again.
Subsection A4 specifically addresses circumstances that are beyond the control or outside of the control of districts and campuses. It makes perfect sense. How would you hold someone accountable for something that they literally have no control over? That is actually in statute a limitation on the commissioner's rulemaking authority. Now, obviously, in this case, again, it was an agency decision to change the test and the accountability simultaneously. I think they overreached. I think that caused a lot of the deadlines to be missed. That wasn't a mistake made by students. It wasn't a mistake made by teachers or campuses or principals or parents or the legislature. That was a decision made solely by the agency. Second limitation on the agency's rulemaking authority. And this is not simply a timeline that the agency can say, well, we like it or we don't like it. 39051 is about adoption of indicators and standards. That's rulemaking. That's not simply publishing something by a date. That is authority to adopt a rule. And there are 2 constraints in statute on rulemaking authority. One, it has to be during the school year, and if you look at the legislative history, in 2017, that initially said by September 30th, and it was during the legislative process that it actually was developed to say adopt during the school year. That is a constraint.
Doesn't it say at any time? I mean, couldn't
At
they do
any-
it on the last day of school?
You could do it at any time, and again, that was a legislative decision, but it also has to be, there's a second constraint, it has to be before districts are evaluated. So there are 2 constraints. It is undisputed in the 22-23 school year, no indicators and standards were ever adopted at any time during the school year. The commissioner did not adopt indicators and standards for the 22-23 school year until we were over 3 months into the next school year. That is outside of his rulemaking authority. The agency's argument appears to be,
So I hear you, but maybe I missed it. I didn't see anything in anybody's briefs about this being subject to the APA rulemaking procedures. Did I just miss it?
we are not arguing that it violated the APA. We're arguing that it's simply outside of his authority conferred by the statute. We're not arguing that it was a procedural violation of the
'Cause that wouldn't
Administrative
work at all.
Procedures
You've got to
Act.
have public comment and all this stuff.
Correct.
The legislature didn't suggest
That's
that.
not our argument. Our argument is he simply did not have the authority to adopt the rule in November of 23. Think of this analogy. It's fall, it's football season in Texas. 2 teams play a game on Friday evening. Teams leave and go home. 2 weeks later, the refs get together,
Skip to the end of the ball game.
decide on the rules, decide field goals are worth 5 points instead of 3 points, call the teams 2 weeks after the fact and tell them who won or who lost. That's functionally what happened here.
Thank you.
Thank you.
Mr. Thompson.
Mr. King.
I'm sorry, you're Mr. Thompson. Mr.
I'm
Campbell.
Mr. Thompson.
Too many Davids, I guess.
Ah, so where is the time deadline for,
You aren't anxious to get out of here, are you?
I mean, where's, no, not your time deadline, the time deadline for the commission.
Understood. So actually, let me jump ahead to that, Chief Justice Brister. I'll scrap my intro and just jump straight to the meat. If you turn to tab 1, I try to just summarize the way that we have tried to explain in our brief how the legislature meant for this to work. Justice Ferris, you had mentioned, wouldn't it be a good idea if the commissioner adopted and announced these rules ahead of time? Not only is it a good idea, it's a good idea that the legislature had. And so if you look, and you have to read the statutes together, right? I mean, this is not a case about a single statute, a single publishing deadline. It's a case about the statutory scheme. So, Justice Brister, if you start in Education Code 39.054, as Mr. Thompson mentioned, that gives the commissioner 2 options. It's a fork in the road. Either you go to subsection A4, which allows the commissioner to assign not rated, which he's done before, or you opt into the rulemaking regime. The rulemaking regime starts with, and I've highlighted in blue, that the commissioner shall adopt rules to evaluate school district campus performance. Now to your question, how do we know that that means before the school year starts? If you go to 39.0541, that says anytime during the year you can adopt indicators and standards. So which school year? Well, keep going. 39.0542. Each school year, the commissioner shall provide each school district a document in a simple, accessible format that explains the accountability performance, measures, methods, and procedures that will be applied to the school year. Now, I understand, well, let me take a step back. I suppose there could be an argument about whether that means that document could be adopted sometime during the school year to provide all the measures, methods, and procedures. Doesn't make a lot of sense, but I guess that argument could be made. In this case, the only document that does that is the accountability manual. That's why I put 39.0541, 0542, and 054 together, because really I think what the legislature is trying to do here is say, Commissioner, adopt by rule an accountability manual that adopts indicators and standards and explains the measures, methods, and procedures that will be applied. Now,
Could you help me, though, with this language in 0541? It says at any time, which seems to indicate that he could do it on the last day of school, and there's no harm, no foul. I mean, the fairness almost seems like a due course of law argument, which you may not be able to make here, and I don't understand this to be a due process case, but I mean, when the legislature says at any time, you know, maybe nobody wants to play Calvin ball, but if the legislature says we get to play Calvin ball, then don't we get to play Calvin ball?
right, so I think if we were in that situation where the legislature hadn't given us rules, then we might have a due process challenge. But let me just stick with the statutes, right? So indicators and standards are what is measured. If you read the statute, the legislature has given certain indicators and standards that must be used, and given the commissioner some discretion to adopt other indicators and standards. But telling us what is measured doesn't tell us how it's measured. That is the methods and procedures. Now, I want you to just take a step back from the statute, go back to law school. Imagine if the law school had a rule, which I think most probably do, that said each school year, the professor shall provide each student a document in a simple, accessible format that explains the grading, measures, methods, and procedures that will be applied for that school year. I think everyone would read that to mean before the semester starts, students are entitled to know how the professor is going to grade them. And if a professor read that statute,
Not if it's at any time during the school year. That could be the last day.
so the at any time during the school year is for the indicators and standards. That's just the what is measured. So at any time during the school year, the commissioner can adopt indicators and standards. But then the question is, okay, now we've got new standards, we've got new indicators. How will they be measured? And that's where you have to go to 0542 and say, whenever the commissioner adopts indicators and standards, each school year, the commissioner has to provide a document that explains how those measures, methods, and procedures will be applied for that school year.
And that, I mean, there's some logic to that, for sure. But I mean, I guess what I'm struggling with, and maybe you can help me, is we're here on ultravirus. And so why wouldn't the option be to, you know, try to force the issuance of that at an earlier time versus trying to, you know, stop the release of the grades after it's in hand?
So, Justice Ferris, I think obviously that would be ideal. The problem is that this school year, it was like boxing with Jell-O, right? I mean, the standards kept changing during the school year. Now, my friend on the other side mentions this March document. If you go through the record, and there's a lot of testimony about this, there was one standard in September, and then later in January, there's some changes to it. Then in March, there's a new standard. There's even testimony from Ms. Tian, I don't have it in front of me, but there were even some representations the commissioner made about things that wouldn't change, like graduation rates, that actually did change. Justice Brister, you had asked about some of the changes. If you go read Dr. Blaine's testimony, it's pages 151 through 153 of the transcript. She described some of those changes that were made, and there weren't just two, there were many, many changes that were made. There were some,
Let me skip to the end. We've got a limited amount of time here, 151 and 53. I'll make a note of that. So 2 questions. First, on my 151 question. I mean, what part of that, I mean, you're here on a temporary injunction. To prevail on a temporary injunction, you've got to have irreparable harm. How can you possibly have irreparable harm if there's an administrative procedure where every one of your clients can challenge the ratings they get?
So there are 2 answers to that question, and I couldn't, because I just have the written document, I couldn't find the exact page, but in Intervenors Exhibit 15, there's a slide presentation from the commissioner that explains the appeals process. And what the commissioner has represented to school districts is that in that appeals process, the appeals process is not a permissible method to challenge, a permissible method to modify the calculations adopted by the commissioner by rule. Now, of course, here we didn't have a rule to challenge. I mean, that rule, my friend on the other side mentions it was adopted. It was adopted after the injunction was entered in this case. I mean, certainly never during the school year, and never while this case was being litigated in the trial court did we have a rule. But I'll see if I can maybe file a supplemental brief with the precise page, but I think it's Intervenors Exhibit 15. So that's one thing.
Okay, what's the other one?
Second thing is, Justice Brister, the commissioner has often taken the position, and at times successfully, that once he has done something, then if you challenge it, you can't challenge it because the ultra vires challenge would be retrospective in nature. And at least one court has agreed with him. If you look at the Third Court of Appeals opinion in Progresso ISD, or sorry, I think it's Morath versus Progresso ISD, the court said, assuming arguendo that the commissioner did commit an ultra vires act, nevertheless, he's already done it, so it's final, it's over, and therefore King's X. So it's a classic, heads I win, tails you lose type argument.
But that was on the ratings, an appeal of the ratings of the statute, or was that something else?
That was, no, it was something else, Your Honor, Justice Field. I think that was, that had to do with attendance at a school and how that was being calculated. So, but that's the concern for a client.
Sure. There may be limitations on what you can raise in a challenge to the accountability rating for your district. But if it says, if you've had an opportunity to do that, you can't do anything else, you can't defeat that by running into court first and preventing the issuance of the ratings. That just doesn't seem right.
I understand the argument, Justice Brister. I think if we did have an opportunity to go through that process, which has never been argued by the other side, so we've never briefed it, and I understand.
It's unfair, but it's immunity, and immunity is unfair.
I understand. I'm on the other side of that argument a lot of times. And so, so all that I would say, Justice Brister, is if we had an opportunity to exhaust administrative remedies, obviously we would have done so. But because the commissioner had represented that we couldn't, based on that exhibit I mentioned, I mean, it brings to mind that, I think, the Mosley decision from the Supreme Court, that you can't, on the one hand, I think in that case, I forget what the agency was, but it was an agency that basically told someone, here's your deadline to appeal. It turned out that that wasn't the deadline to appeal. And then they tried to argue later, well, you shouldn't have taken us at our word. So I think that there would be a due process problem if the commissioner were able to, on the one hand.
Is there anything in the record saying you all could not, if you'd allowed the ratings to be issued, that you all could not challenge them and straighten them out? My problem is irreparable harm. And if, oh, we're all afraid we're gonna get Fs and this, that, and the other's gonna happen, but if you can reverse it and get a D or a C or a B or whatever you're gonna get, how can you possibly, until you try, how can we possibly know there's irreparable harm to your district?
I think there are 2 or 3 answers to that if I can remember them. We'll see. I mean, one answer to that, I think, Justice Brister, would be if the ratings were assigned, if you go through the superintendent's testimony, there were 4 superintendents that testified, each testified about the harm that occurs once the ratings are released. So if the ratings are released and then you can challenge them, and maybe a year later it gets changed, the harm has been done.
But the harm is that people will believe them and I don't know, move their kids to a private school or something else, or the staff will leave, which was, as I understand it, one of the purposes of the accountability ratings. I mean, why are we publicly publishing this school district or campus is an F if we want people to stay there? The legislature wanted people to know so they could vote with their feet. Why? I mean, who is the rating system for? Is it for parents and children, or is it for schools and school administrators and school teachers? It can't be the latter.
I completely agree. And so, Justice Brister, that is why the school districts in this lawsuit are so concerned with the ratings being accurate and not having it gotcha. You know, I can remember back in school, I don't know if they do this anymore, but they used to have the presidential fitness thing that you would do, sit-ups, run a mile, whatever. And as a kid, I had asthma. So I had trouble meeting the mile time. So during recess, you know, when other kids were playing tag, I would run to try to get to that cutoff because it wasn't easy with my inhaler in my hand. And at the end of the year, I managed to make that cutoff. And I can't imagine how I would have felt if at the end of the year, after working so hard to raise to that standard, someone had told me, actually, it's not 8 minutes. We decided to make it 7 minutes, and you should have just tried harder.
It makes perfect sense for the legislature to say that. The question is, where did they say that?
So we provided the statutes where the legislature said that, Justice Brister.
Well, I want to follow up on this question because it's crystallizing something for me. Isn't the problem we've got here that if you had filed suit saying, wait a second, you haven't made this rule yet and you haven't done it timely, court, make them do it timely. That's the ultra-virus claim. But if you wait until after the manual is done and all that's left is to issue ratings, then don't you run into the problem that what's the irreparable harm because you have a means to challenge the actual rating? In other words, isn't the problem we have here in some ways that the ultra-virus conduct is a moving target, and one of those things has some prospective relief you could get, one of those things doesn't? Does that make any sense at all?
I don't know, Justice Field. I mean, the way that I see it is the reason that we didn't file this sooner is I'm sure if we had filed this earlier in the school year, we would have heard it's not right. The commissioner is still working on the rules because that's what the commissioner was telling us. Behind tabs 4 and 5, you have a letter that school district sent to the commissioner trying to get this worked out. You have a letter from legislators trying to get this worked out. So I think that the problem was that school districts were trying to get the commissioner to tell them the final rules. They didn't want to bring this lawsuit. It was a difficult decision. And so I don't think, again, this is a heads I win, tails you lose type situation where I don't think you can force people to predict that the commissioner is not going to comply with this statutory obligation.
Last question. Why isn't the Technical Assistance Committee an independent agency? Argument in the briefs was, well, they're appointed by TEA and can be reimbursed. I guess they're not paid staff, they just, reimbursement of expenses?
So they actually are paid.
Okay.
They are paid something, we
So-
don't know how much.
So, of course, every appellate judge in Texas is paid by the state. And the majority of us, or in fact all 3 of us, were appointed to this court. So are you saying, ergo, we are not independent? And in fact, almost all the judges in Texas are not independent. That can't be the test, whether you're appointed by somebody in government and paid by the state.
feel like I need to read him his rights.
I won't take the fifth. No.
Any other way to test independence other than those, because that sweeps too broadly?
Yes. So Justice Brister, three things to say to that briefly. One is,
I would not have expected anything less than 3.
one would be this, that the statute specifically says an independent entity, right? And so it would be one thing, we're not saying that TEA can't hire a third party and can't pay that third party to do a validation study. We know they have done that in the past. As far as we know, not since 2016. But we know they could do that. The problem with this committee, and one of the arguments, the first argument we have made, is that it's not independent because this isn't an entity that is out there. It's an entity that TEA has created. They chose who was going to be on it. They paid them, yada, yada. You have that argument.
Right.
The other thing that we have argued, and if you just look at, I think it's behind tab 2 of the bench book exhibits that I gave you. It's really a statutory argument because honestly, when this committee came up in the hearing, no one knew who this committee was. There's not much out there about it. We know the individuals on it, but we don't have minutes. We don't know how often they meet. We don't know what happens at those meetings. And that's not surprising because when you look at 39.02302, which is behind tab 2, you see that the legislature has said the purpose of this committee is to advise the commissioner and the agency regarding the development of the test. So it's not just that they're not independent, it's that the whole point of this agency is to be this entity is to be an entity that TEA gathers to help them develop the test. If you look at
Tell you what,
39...
Since you're gonna file, we need to move on. Since
Okay.
you're gonna file a post-sub letter anyway on 151, why don't you put your other arguments in there?
I'd be happy to, Your Honor.
Thank you.
Thank you for your time.
Ms. Clustman?
May it please the court. So we're not contesting that the commissioner did not adopt the accountability manual during the school year. Obviously, that happened outside the school year. The question for the court is, so what? Does that mean that he can no longer issue accountability ratings? Is his authority to do so been removed by statute? Or can he still, then Judge Gorsuch's word, better late than never principle, still issue accountability ratings even though they are after the time period the legislature originally envisioned?
What if they filed their suit a day before the school year ended and said, court, they have until tomorrow. No indication they're going to do it. That's ultra-virus conduct. Issue a mandatory injunction making them do this. What's the response to that?
I think it's an interesting question. I think the Supreme Court left open in Lampasas is if you do see that deadline approaching, are there judicial methods you can use to enforce it? I mean, the waiting until one day before, I think certainly presents some practical problems.
I wouldn't appreciate it.
But I mean, that's the argument then you have to have is if your authority would still exist afterwards to adopt the manual, and they haven't argued again that he was ultra vires to adopt the manual late, can you still force them to do it by the deadline? And I think in that case, I mean, just practically speaking, you're probably going to have to look at the next year just because doing it one day in advance isn't going to work. But that brings up the question, I mean, they knew back in the fall that this manual wasn't going to even be proposed until the spring, and his usual practice was to adopt it over the summer. If they believed they had a statutory right to that information at the beginning of the year, that's when you should have filed your lawsuit, instead of waiting until everything was done and trying to eliminate accountability ratings entirely. I want to address what Mr. Thompson said about Section A4. That is a discretionary option. It says that the commissioner may assign not rated in certain events, for example, hurricanes or data breaches or things of that nature. So it's discretionary. It is not a mandatory thing that the commissioner must do.
And how many years during the pandemic, et cetera, have we had everybody not rated?
Sure, in 1920 and 2021, he issued not rated. In 21-22, there were abbreviated ratings. The legislature said you can get A, B, C, and then everyone below that was just a not rated. So honestly, we are looking at since 2018-19, since we have had accountability ratings. And that's going to explain why the commissioner said we're not going to, I mean, they talked about 40 years of tradition. We've been so long without accountability ratings, we need to have them now. That's why he wasn't putting this off. So again, tradition is not law. The law says that he is permitted to issue these ratings, and there is no statute that removes his authority to do so.
What checks and balances are in place if an F rating is erroneously issued?
Again, I think that's when you would use 39.151.
And what happens to the school district that's happened to, if people have left, transfer? When is the deadline to transfer to another school? My understanding is you can do it almost any time, isn't it?
I assume, I mean, I don't have any kids in the system, so I don't know when you would do that. I think most people probably try to have their kids lined up at the beginning of the school year, but you can
gotta
probably.
have an opening where you want to go, but
Right.
you can.
Right.
And so if people start transferring out, what resources helps school district in the interim for the daily funding they've lost because these students left?
I mean, that's how you stole my thunder a little bit about, this is about the students and making sure that the students are getting their education. And so we have testimony from several superintendents about how they turned around their districts. It can be done. There are ways to get it done. But that is just one of the consequences of the accountability system, is we need to know, are these districts performing? And if not, what help do they need and what remedies are possible, so that we can ensure that, you know, the legislature is meeting its constitutional obligation of providing an education to the students within the state. Quickly on what we call TTAC, I think if you just look at the 3 statutes that discuss it, all of them talk about a determination that it is valid and reliable. The TTAC is supposed to help make sure it's valid and reliable, and 39023A14 talks about findings and recommendations, whether or not it's valid and reliable. I mean, this is the entity that the legislature has identified as making this determination.
Doesn't the statute require empirical data to test reliability, and if so, where is that in the record?
The empirical data, I think the testimony was that, I think of it this way, Your Honor, in the sense that the FDA sort of looks over the shoulder of people who are developing drugs. The TTAC sort of looks over the shoulder of TEA and its vendors while they're developing the test. So they watch what they're doing, they see the results that are happening, and they advise on whether or not what they're doing makes it valid and reliable. So the empirical data that they looked at is not in the record because it was not our burden to prove it. It was their burden to prove that it hasn't been done. But if the case goes further, there may be an opportunity to put that in the record. So for those reasons, we ask that you would reverse the temporary injunction and dismiss the case.
Anything further? We'll take a 5-minute break. Case will be submitted, and we'll start in 5 minutes with the second case.
All right.